is a Thursday edition. Let me take this to get right into it to sincerely apologize to you, our listener, for obviously having waited for a while, waited for this particular program. And we are starting now simply because our guest had some engagement, parliamentary engagement this morning. And so he excused himself from that committee to come and be on this program, and hence the delay, because again, he got caught up in traffic. And by the way, we are still grateful that him, our listener, for having exercised some patience. Otherwise, we are with our programming on this Thursday edition. And our guest is Honourable George Chisanga. He is the Patriotic Front Legal Committee Chairperson and Lukashya Member of Parliament. But let me quickly also say that we are live here on 5FM Radio in 89.9, and also on our partner radio stations, Katete FM, the entire Eastern Province. Would you be that? Yes, they are tuned in, and we are live on 103.3 FM, and live on Spice FM in Kabwe and Central Province, and 91.1 FM, ZFM in Kapiri on 100.3 FM, and we are live on iWave FM in Chingola, covering the rest of the Copper Belt on 9.1 FM, and I'm radio in Ndola as well, covering the entire Copper Belt on 99.7. Remember, we are also live on Tuta FM in Masa, and Tuta FM is on 90.7 FM, covering the rest of Wapula Province. And last but not the least, Muchinga Radio in Chinsali, covering the rest of Muchinga Province on 88.1. And I'm your host, Zachariah Banda. Like I already said, our guest is Honourable George Chisanga. He is the Patriotic Front Legal Committee Chairperson and Lukashya Member of Parliament. It's a pleasure to have you. Welcome to the program.
Zach, I'm honored to be here again. Thank you very much. And I want to thank you, Radio 5, for exercising patience, and also the listeners and all the partner radio stations for giving me this. As you indicated, I was only notified of this program yesterday, but just a few programs, including parliamentary programs. I thought it was very important to share these views that you requested. I'm very, very grateful that this opportunity was given to me.
Right. So what we'll do is we'll get right straight into our conversation today. And our conversation today is obviously a conversation that you've had interest in yourself. And other than that, you were also a witness appearing before a committee. And we are going to discuss Bill 13, Lands and Deeds Registry Amendment.
That's right.
First of all, tell us what this bill intended to do.
Okay, so we were dealing with a singular proposal to amend one provision of the Land and Deed Registry Act, introducing in that act a section that would be called Section 57A, which was going to confer powers on the Registrar of Lands and Deeds to, among other things, cancel certificates of title or refuse to grant a certificate of title if she thinks that you're not eligible for grant of a certificate of title. Basically, that is what this bill, in general terms, was intending to do. So the concern by the stakeholders, arises from various perspectives. The major one of which is that this was going to be a very deep land reform that could not be effected without government demonstrating that they had consulted stakeholders. I had the opportunity to say earlier that what makes this very classic is that the UPND, when they were in opposition, they spoke very little about what they would do to law reform, about what they would do to constitutional reforms, and they primarily focused on what they were going to do with the economy, so that there was no talk about how they are going to help reform land legislation, for instance, how they are going to reform the constitution. There wasn't a loud speech in that respect. In fact, I had argued that the UPND didn't have a manifesto. What they had was what they called a 10-point plan of how they intended to come and govern. And the focus, even in the 10-point plan, was how they're going to, revitalize the economy. So when they came into power, the earlier time Zambians were trying to gauge was how they were going to deal with the economy, which is why Zambians were interested in seeing how the UPND was going to handle the affairs relating to mining, how they're going to handle areas relating to farming, how they're going to handle areas relating to finance, and other respects. But suddenly they began talking about law reform. They began talking about constitutional reforms. Now, there is something interesting about how you should handle law reform. Every time you want to change a law, you must demonstrate that every stakeholder who is implicated in that law will be consulted, their views will be sought, and frankly speaking, in democratic terms, their views will be respected. Okay, but the way UPND has been going about this law reform, including constitutional reform, is that they seem to be deciding on their own and then coming to ask the people's views after they've made a decision that they're going to amend this law. The same thing happened if you saw how they came to amend I think the one that had to do with stock theft. How then if you were going to be arrested for stock theft for the second time, you will not be bailed out. People just got surprised that there was a law in Parliament that was suggesting that a person who's arrested for stock theft for the second time would not be entitled to bail until the matter ends before the court. And others started asking us questions as MPs. Where were you when this law was coming? But you see, we were also caught up in the same conundrum where you just wake up, you hear there's a bill, and you go to Parliament to try and argue against it. It just passes. Okay. The other thing they also did was how they amended the penal code to remove the death penalty. At least you could give them credit to that because they had spoken to the need for them to abolish the death penalty. But again, we questioned how they managed to come to Parliament within a short space of time and amend only the penal code, to remove the death penalty. But we have argued that the death penalty has remained in the Constitution, which is a supreme law. And the argument was that even that itself was not correct because they ought to have first amended the Constitution and then amended the penal code to remove the death penalty. You see, and if you saw even the issue of cyber crime legislation, it's all controversial. But on this particular one, we were very, very concerned as a Patriotic Front, and I think other stakeholders, that you now have a government that, without showing any amount of consultation, decide to come up with a singular amendment in an important law such as the Lands and Deeds Registry Act, and suggest to you or to the nation that now they are going to give the registrar of lands power to cancel certificates of title. And this is coming at the backdrop, if you heard, when the president was expressing his concern about how people are toiling with land titling systems. And he was saying, look, this is a new government. We're going to make sure that people just won't be running around with title deeds, etc., etc. We didn't know exactly what he was saying. And then you come and hear there's a proposal to amend the law in such a controversial way without consultation. And this is why we all, as stakeholders, rose up and said, no, you can't amend the law in this fashion. And we went to the committee and presented our views, and the committee gracefully was able to listen to the views of the public and decided to do what you saw the minister did on the floor of the House yesterday, to defer this piece of legislation. I have argued immediately that even that deferment in my assessment was not correct. What we should have seen was actually withdrawal of that statute, because the reasons that were given to the committees by the majority of the stakeholders suggested clearly that this was going to be a problematic amendment. You don't even...
Was it majority stakeholders in this case? Because I think that those who were for were less, and those who were against were more. Is it five out of four?
I need to check that record, quite frankly. If there were more, we still have a problem, because the reasons that were advanced by those who said we shouldn't amend the law, and the reception that view has received from the public clearly shows that the majority of Zambians do not agree that we can amend a law in this fashion and introduce such a big power to the registrar.
Let's get it right. If you are against the fact that this amendment gives power to the registrar to cancel title deeds, for example, or title deed certificate, for example, what's the status quo? What is the procedure now versus what is being proposed in amendments?
The very act, the Lands and Deeds Registry Act, has a provision in Section 33 and Section 34 that allows you to challenge, a title if you think that somebody who's holding a title either obtained it fraudulently or illegally, or there's something untoward that you must utilize.
Right.
But what is classic, Zach, is that in the current provision, you don't go to the registrar and complain, and the registrar exercises powers to cancel the certificate of title. You actually go to court, to the High Court. The power to cancel certificates of title is by law and the Constitution conferred on the High Court. And this is not unique to Zambia, like I said, when I appeared before the Committee of Parliament. This is what applies in most of, if not all, the Commonwealth countries who all held or who all obtained their laws from the legal system that applies in the UK. But look, to contextualize this issue, let me tell you the importance that in England, even today, they place on land tenure systems, okay? A law as important as the law relating to holding certificates of title or title deeds, it has existed, like I said before the committee, for more than 810 years. Now, that's a classic. You need to be able to find out what is wrong with law that has been in place for 810 years for us to suggest today that we must amend that law. Okay, when I appeared before the committee, because they gave me 10 minutes, I didn't speak to the detail of the brief that I had given them before I went. But in that brief, I had discussed the concept of how we came up with the current land tenure system, which has existed, like I said, for 810 years. It was back in 1215. In fact, the fight started in 1214, when England was that kingdom, the historical kingdom, with the king, the barons, and the people were called subjects. They're probably not even called citizens at that time. They're called subjects. And at that time, the king wielded absolute power when it came to land ownership and land management. And other areas of governance also were implicated at that time. And people started waging what would have been a very big revolt, not only in England, but also elsewhere within, the European enclave. Because if you remember, the UK and other countries within Europe are all they are all an offshoot of the Roman Empire. So they knew what they expected from the king. They knew what powers the king would have. So they actually were trying to wage a revolt. The king, in trying to make sure that they have vetted that revolt, decided or agreed with the barons and the subjects that we are going to etch our relationship in terms of governance, and most importantly in terms of land ownership and management, in what they considered, what they called the Magna Carta. The Magna Carta is a document that everybody that has been to law school and other people that have studied political science will tell you was like the first written constitution. Now, in that Magna Carta, I want to read to you what was contained in clause 52 of the Magna Carta. This is 1215, by the way, so it's almost 800 years. And this is what they said about how they are going to deal with land ownership and use. They said, to any man who we have deprived or disposed of lands, liberties, and rights without lawful judgment of his equals, okay, we will at once restore these lands. In case of a dispute, his matter will be resolved by judgment of 25 barons, okay, referred to below in the clause for securing peace. In cases, however, where a man was deprived of or dispossessed of something without lawful judgment of his equals by our father King Henry. Remember, there was a King Henry before King John took over, okay, or our brother King Richard, from whom King John took over, and it remains in our hands or is held by others under warranty, we will have respite for a period commonly availed to crusaders, unless a lawsuit had been begun or an inquiry had been made to our order before we took cross as a crusader. On our return from the crusade, or if we abandon it, we will at once render full justice. Now, let me paraphrase that clause. That clause simply said, from the time of enacting the Magna Carta, they were going to allow people, the king was agreeing to restore land that he had acquired from people immediately using the barons. And that if there was going to be any dispute on ownership of land at that time, that dispute was going to be resolved by a committee of 25 barons. At that time, in 1215, 25 barons. And if there was land that had been illegally acquired by the king from subjects, and it had been held on behalf of the king by the barons, they were agreeing in 1215 to return that land immediately. Now, that showed you that from as far back as 1215, there was a system that was put in place, firstly, on how the king was going to allow people to own land, okay, on title, and also on how, in the event there's a dispute on ownership of land, that was going to be resolved. If you hear what they're saying, they were going to appoint a committee of 25 barons to look into that issue and determine whether the person who's owning land is owning it legally or not legally. Even the lands that had been acquired before King John took the throne, they were undertaking in the Magna Carta that even those lands were going to be restored to their owners using respite. And if there had been, the Crusaders, like other people that had taken land but they'd gone out of the country, because that time Europe was beginning to explore. England was beginning to explore outside England and elsewhere for land. They said on return they would make sure that they do justice to anybody whose land had been deprived of. Now, this is a very classical provision, like I said to the committee. And this is what has formed the cradle of land titling for the past 800 years, not only, in England, but everywhere in the Commonwealth, including Zambia, which inherited its laws on land titling from the UK. So the question that somebody needs to ask is, what was wrong with that system? What is wrong with a system where if you, Zach, somebody thinks you're not owning land legally, they can't just go to the registrar and say, please cancel that title deed. They would have to go to the High Court because this is a law that we put in place for ourselves. And we've respected this law for the past 60 years. Without instigation, government decides they're going to change it today without consulting the stakeholders. Now, when the stakeholders rise and say, no, you can't do it, we are okay with the system that is applicable currently, what does the government do? It's supposed to respect the views of the people and decide they're going to allow the land system to remain being managed as it has been under the Lands and Deeds Registry Act. The question you asked and I answered it is that we have provisions currently in the law that allows you to question land holding and titles. And the High Court has got power to cancel a certificate of title if it was issued irregularly, if it was issued through fraud, if there's some illegality, supervening illegality that causes somebody to lose the title to land. The issue is that it must be determined by a judicially constituted institution like the High Court. And what I said to the committee, and I can repeat here, is that you see, the reason why you cannot introduce this provision, a single provision in the Lands and Deeds Registry Act, is you cannot by a law suggest that you can share the jurisdictional power of the High Court with an institution such as the Registrar's Office, whose responsibility is mainly to maintain the particulars which are registered on a piece of land. That's the responsibility that the registrar has. So you can't share a constitutional mandate of the High Court because the High Court is set up by the Constitution. And the Constitution provides that the High Court is going to have, an unlimited jurisdiction, okay, in terms of determining disputes, including land disputes. So you can't take that constitutional power and then vest it in the registrar for convenience. You can't do that. So this is the reason why we went to that committee and told them that we don't think that this is a progressive piece of legislation. It must not be enacted.
Yeah. So are you saying that in this case, if powers are given to a registrar, the court process is irrelevant? I mean, there will not be any existence of court process in
there is a proposed appeal procedure in those provisions.
Yeah.
But you see, for me, aren't you just even creating a problem? If today, if I want to resolve a land dispute relating to ownership and title deeds, I can go straight to the High Court, and the High Court makes that decision. And litigation is expensive, by the way. Okay, and then there's a tier system from the High Court.
That could be the issue. That could be the issue because the current situation is expensive for an ordinary Zambian out there.
It can't be the issue. What makes you think that if the registrar cancels my title deed, I can't appeal to the High Court? So you're actually elongating the process. Because if the registrar today says, I'll cancel your certificate of title, and there's a provision, in fact, there's a very awkward provision in there that says that you can appeal to the minister.
Yeah.
I said before the committee that what previous governments have done in this country has been to depoliticize land management. because of how important land is, both to the economy and also for people to just know that they've got rights to ownership of land, which is provided for even in the Constitution. So the previous government have tried as much as possible to depoliticize anything to do with the resolution of land disputes. What you see in the provision that is being proposed now is that there's even an appeal procedure, okay, that if you don't agree with the registrar, you appeal to the Minister of Lands. We have argued, and everyone has said it to the committee and to the nation, that the Minister of Lands is there to, dictate policy, government policy on how to do land management. Issues of land management, titling, etc. What the Zambians have agreed from as far back as 1973, when Kaunda read the watershed speech, was that the president of the Republic of Zambia is the one who owns the land in this country. And he owns it not absolutely. No, he owns it as a trustee for and on behalf of the Zambian people. And that's why when it comes to land management, the president then is mandated to issue a commission. Okay? The commission is a power that is exercised by the president appointing an individual called the Commissioner of Lands to be able to administer land management and titling for and on behalf of the president, who owns it for and on behalf of the Zambian people. That intention was a clear declaration of the need for us to depoliticize the management of land in the country. You have never seen under UNIP, you've never seen under MMD, you never saw it under PF, that there would be an appeal procedure in land management that allows the minister to be able to make determination of whether the registrar was right or not. And then from a minister, you go to the court. This idea of even elongating the process is very bad when it comes to land management, because land must be owned. People must be allowed to enjoy, that land unrestrained. But if you're going to put in provisions that even suggest that first you have to go to the registrar and exercise a constitutional power, to cancel a certificate of title is a constitutional power that is vested in the High Court. That's what you must understand first. If you understand that yardstick, then you would have no difficulties in agreeing with why we don't agree with what is being proposed currently, because you are actually sharing a constitutional mandate with the registrar, whose responsibility only is to maintain what is contained in the registrar. It might sound, for me as a lawyer, you cannot replace an imperative with a convenience. And that's a problem I've had with the UPND government, not only in this area, but in every area. The UPND will only comply with the law if it is convenient to them. But you see, a law is dictated to be an imperative. When the law says the president is going to be in office for 5 years, you have to be in office for 5 years, finished. When the law says the MP is going to be in office for 5 years, you have to be, that's what the law is designed to be. But when you begin to think that you can treat the law as a convenience, this is where you begin to think that you can quickly take a constitutional power and dilute it and give it to somebody who's running a registry and think that you have done something correct, and because it sounds convenient to you for the time being. You see, and the laws, laws have got certain aspects that non-lawyers, for lack of a better term, do not consider. Okay, a law that you can pass today is a law that can come knocking on your door the other time. I was privileged one time, Zach, to sit on a commission of inquiry that was put together by President Michael Sata to look at various matters of justice and legal reforms. Unfortunately, that committee didn't finish doing its work, but I can tell you the work that we did at that time between 2013 and 2014 was so massive that if we had tried to implement what we had collected, we would have had a better legal system currently, because we would have responded to most of the issues that people were raising concerning the pitfalls in the legal system that we have in the country, because there'd been no law reform for a long time. Unfortunately, Mr. Sata died, and when President Edgar Lungu took over, that commission of inquiry was abandoned. But I'll tell you one thing that I learned in that commission of inquiry. My own father, General Mianda, came and appeared before my commission of inquiry to come and tell us that we should again amend the Public Order Act. I was astounded myself, because I've been a follower of politics for a long time. When General Mianda, my father, was vice president in this country, okay, somebody questioned the powers of the police under the Public Order Act. That case went to court, and in court, the court made a decision that the Public Order Act, as it was at that time, was unconstitutional. Okay, General Mianda, being the vice president, I think was lobbied by cabinet of Frederick Chiluba, came back to parliament and reenacted the Public Order Act in the current form that it is currently. Okay, he was a vice president for the MMD at that time. Peradventure, he moved out of MMD because of that fight on the third term and set up his own Heritage Party. From the time General Mianda set up Heritage Party, he was not allowed to hold a single public rally. And it resulted in a man as good as General Mianda not being a president in this country, because he was not allowed to canvass. He was not allowed to speak to the nation about what Heritage Party stood for. He was restrained because of public order, the one that he brought back to Parliament for enactment. When that commission of inquiry was put together by Michael Sata, he was one of the people that came at Civic Center in Lusaka and came and said, I have come to apologize. And you see, General Manda is a very honest politician. He actually said, I've come as a man who is ashamed that I allowed a system that we put in place that has restrained people from exercising their rights. So I have come here as a man who wants to tell you to undo what I did. And that's what people don't consider when you're making provisions like the one that is being suggested now. Everybody in UPND can be very comfortable today because, you see, using the power play of politics, nobody's going to ask them to surrender a certificate of title. If George Chisanga became a president next year, and he doesn't like Mr. Zach because Zach belongs to the UPND, I can instigate the registrar and say, cancel that certificate of title. These are issues that are real, and we brought them to the fore when we're discussing with the commission, with the committee. And our thinking then is that we should be able to look further beyond political patronage. We should be able to look further beyond the existence of political party in power and know that there are certain things that you can never change. There must be something special about why this law has been in place for more than 800 years. You must just be able to think and say there's a reason why, but also you see it in practice. There's an area, anybody who is a landowner here will come and tell you. Even now, we have a problem with land management when it comes to re-entry. Exercising the re-entry, the powers that the Commission of Lands has to re-enter properties. People are losing properties left, right, and center because workers in the Ministry of Lands, in connivance with certain individuals, are making re-entries, which is a power that the Commission of Lands has, in a way that is either fraudulent, that is illegal, and cases in court, there's a backlog of cases in the High Court where people are challenging these so-called re-entries. Now you want to open another window, which can be abused by politicians? No, that's not how you run a country. And this is what we are telling our colleagues. When you have to make law that is going to survive your power, your stay in power. So that even when you are retired, even no longer a politician or no longer a minister or even a president, you can sit at home knowing that nobody's going to knock on your door and tell you a certificate of title has been cancelled. That's the reason why we've got the High Court as the only institution with power to do what we are trying to give the registrar of lands to start doing right now.
Interesting. But then if we still need, much as yes, the law has stayed that long and there must be a reason why it hasn't been tampered with, there's always one thing that we know about bills. Sometimes bills or amendment bills will actually give you a good side, a good thing of it, and the other side, a bad thing of it. Is there anything good in trying to amend the Land and Deed Act that you think can make it even better? Because we still have problems, like you are saying. Yeah. But what can we do if we were to amend it with consultation, for example? What would you be looking for? What submissions would you be looking for?
Look, leadership does not entitle you to fail to reinvent the wheel. It doesn't. Leadership always draws on the lessons we learn from history. Okay, the watershed speech was not just a speech made by Dr. Kaunda at the material reforms. It was a speech that resulted from wide stakeholder consultation. Okay, the current system that we have now, which is more democratic than the one that UNIP was managing the country with, demands of those who are in leadership to exhibit the capacity to consult on everythh that they do, because democracy is consultative. Democracy is a compromise form of leadership. You must demonstrate that at every age that you're doing something, you have widely consulted about the subject about which you're going to make a decision.
For the people, by the people.
I was living in England myself. When you arrive, even as a student, they make you amenable to payment of what is called poll tax. It's a local authority tax, that you pay. But that tax alone allows you to go and sit in town halls and participate in everything that the local authority is trying to do, simply because you're a taxpayer. Okay, one of the experiences I've had, which has remained embedded in my head, is when the Cambridge Council wanted to remove a tree that had been, according to the people, planted and stayed there for over 200 years. But see, they were giving way to try and put a highway where the tree was. Believe it or not, they called the town hall. in which there were not less than 500 people to go and just discuss whether the council had power to remove a tree or not. This is the kind of democracy that we're doing right now. What we need to do as the UPND government is to demonstrate that we will be consultative in everything that we're going to do. I can bet there is nothing that UPND has tried to do to this country which has been backed by adequate consultation. Nothing. I don't even think that when they went to the IMF, they consulted anybody. They just made decisions that we are going to go to the IMF, and we are living with the vagrancies of the IMF right now. I don't think they consulted anybody when they decided to put up a dual carriageway between here, and Indora. As much as we need the dual carriageway, there's need for us to explain how this is going to happen. Look at the controversy of a dual carriageway right now. People are arguing. Why have you taken the toll gates and given them to a private company? Which private company you had said you're going to give money from NAPSA and the workers' compensation to construct a road, and after the road is done and finished, then you transfer the toll gates to them. But before the road is even, a quarter finished, you have transferred these toll gates, because this is a government that has given itself to not consulting people, just making decisions. Look at what's happening to KCM. People now are crying, saying, look, let these people that are so-called investors go back, because they're not doing anything. But the decision was made. First, they were saying they're not going to bring KCM back. Suddenly, they bring KCM. The inability to consult by the UPND is what is causing this governance problems that we are experiencing right now. Bill 7 still suffers the same kind of problems, where they try to bring a bill into parliament to amend the constitution by first creating a deceptive concept, that they are going to amend only non-controversial provisions of the constitution, or what they call the low-hanging fruits. I had said it even on this radio. I said, you can't have a constitution that's got non-controversial provisions. You can't have low-hanging fruits in the constitution. But they went ahead, did whatever they were doing inside, then tried to come and, participate, ask people to participate in the so-called consultation after the bill had already been drafted and presented to the public. I told you when I was on this radio last time that they invited me to go to Kasama to go and participate in a district discussion of the constitution. I received the letter on a Thursday afternoon. I was supposed to be in Kasama on Friday the following day. Who would make that journey between here and Kasama? But they arrived in Kasama and they called people in pockets. They called a group here, a group there, and tried to consult for one day to consult to amend the constitution. Is it the kind of approach they have to governance is what is causing us the kind of problems that we're having right now. So if you ask me a question, what would you rather do? I would rather that we don't amend the Lands and Deed Registry Act piecemeal, and I said it even the other side. You don't pick one provision in the act and bring it to parliament and say, let's amend this, simply because it suits your current whims and caprices. That's not how you amend, especially things to do with constitutions, things to do with land management, because land management is implicated. The Agriculture Credit Act has reference to land management. The Lands Act has reference to land management. The Lands and Deeds Registry Act itself has, reference to land management. The Perpetual Successions Act has. There are so many laws that are implicated in land management that you can't just pick up one clause and say we're going to amend this because it suits you. You need to allow a process where. That's why in this country we've got the Law Development Commission, which has not been utilized by politicians. This is a grouping of experts who can be given information about what you intend to do. If it's land law you intend to amend, you tell them, can you research on all the land laws in the country, figure out how this proposed amendment is going to affect the other provisions. And that is not a job that can be done in 2 weeks. This amendment was being proposed to be effected within 2 weeks. How do you amend such an important provision of the law as the Section 33 and Section 34 or introduce Section 57A into the Act in 2 weeks without showing that you've consulted? This is where the problem lies. Our colleagues would like to, there are certain things they've started doing, okay? And they're thinking that the law is providing an inconvenience for them to do. So they want to achieve what they have been doing already using the law. This is why I said the other time, it's lawfare. You don't use the law in such a way. Law is respected by the legitimacy that it enjoys amongst the subjects who it applies to. You don't just create a law that suits the needs of those who are in leadership. No, in fact, the law is always designed to restrain abuse by those who are in leadership. In very few circumstances, that's when you must enact law that suits those who are in leadership. But in most circumstances, you must always enact law with the thinking that you want to arrest abuse by those who are in leadership. This is why Section 57A, is actually a devil in terms of legal reform.
This is the Thursday edition of the Burning Issue. My guest is Honourable George Chisanga. He is the Patriotic Front Legal Committee Chairperson and Lukashya Member of Parliament. We are discussing everything around Land and Deed Act Amendment Bill 13 of 2024, and of course, which has been deferred. But quickly, before I take phone calls, deferment in this case, again, on social media, it's giving a lot of misinterpretation and interpretations.
Yes.
What does that mean? Does it mean it's coming back?
Okay,
Does it mean we will look at it in future?
Deferment is basically what the minister herself said on the floor of the House, that because they consider themselves a listening government and they have deferred. Deferment simply means they've suspended it for now, but it is going to come back, arguably, possibly after consultation. But you see, I have problems myself with that, because there's no telling now whether depending on the views that they're going to receive from the public, they are going to completely do away with this piece of legislation. And also, there's no telling now whether it is even genuine that they intend to consult. There's no telling. Okay, the good thing is at least we're closing Parliament on Friday, so maybe they can create that time to consult. But here, let me give you examples of what transpired. The CDF Act had come to Parliament. Okay, it was deferred.
Right.
Yeah, on the thinking that they are going to consult people. Okay, when it came back in the same form that it had gone, and they passed it. Okay, the cyber laws that you've been decrying, mostly of you guys in the media, had come to the floor of the House. We raised resistance in that House against the cyber legislation. They deferred it, arguably with a view to go and consult, especially media practitioners and other stakeholders, especially bloggers and others. They went back. It came back in the same state it had gone in. You know, so you wonder whether this government is being honest and decent if they're telling you that they want to defer it because they want to go and consult. They're probably not going to do it. They'll bring it back in the same shape. But for me, if they want to demonstrate that they are listening government, I think they should allow experts, such as a legal law development commission, allow experts such as professors and doctors and other lecturers in law faculties around the country to carry out a thorough research on how this is going to implicate not only the other laws, but also how it is going to be received by the Zambian people. That initiative is going to be helpful because usually researchers don't just end with looking at local content. Researchers will also do what is called the international best practices by analyzing our provisions, or the proposed provisions with other jurisdictions. And I tried to do that when I appeared before the committee. I actually was able to show them that in Kenya, in Zimbabwe, in Botswana, in South Africa, in Malaysia, and in India, all these are countries within the Commonwealth. There is no country amongst the ones I've mentioned which confers this kind of power on a registrar. Everywhere, it is the courts that resolve issues relating to land titling and land disputes. So if the government is genuine, I even heard the minister saying she wants to consult, among other people, chiefs. Chiefs don't administer state land. Chiefs don't even know what title deeds are. Chief administer customary land. And their powers exist from the time land is held on a customary tenure, and they extinguish when the land is transferred to a statutory tenure. A chief will have nothing to do with the land which is held on a statutory tenure. So even the targeted, stakeholders that the minister was mentioning, at least on the floor of the House, are people who are not going to add value to that consultation. If they're going to add value to this consultation, they must go to the correct audience.
Well, this is the Thursday edition of the burning issue, like I earlier said. Now, just like you were witness to the committee or before committee and made submissions against the amendment of Bill 13, we also had stakeholders, other stakeholders that also made submissions. Others were definitely for the idea, and one of the,
as expected,
of course, one of the stakeholder that obviously made these amendments for the amendment of Bill 13 is Mr. Elijah Simbai, who I have on the line now. And good morning. It's a pleasure to have you, and welcome to the burning issue.
Thank you very much, Banda. Good morning, and good morning, Honourable.
Good morning, Mr. Simbai. Thank you very much.
Mr. Simbai, maybe briefly just tell us a bit about yourself in terms of profession and your role in submissions that you made as witness to the committee?
Well, as I've already mentioned, my name is Elijah Silai. I am a private citizen, of course, resident here in Lusaka. And I made submissions also before Parliament on the bill. My submission basically was to support the bill. And appearing before Parliament, I did encounter, in form of questions, some of the issues that Honourable Chisanga has raised. But those notwithstanding, I still was of the view then, as I am now, that the bill should be passed into law. It is good law, and majority of us, some of us, of course, who for quite a long time have cried for a remedy such as the one being proposed in the bill, would have found it very helpful and beneficial. Now, firstly, of course, I'd like to commend Honourable Chisanga because the way he has dealt with the issue, so far as the characterization of the bill goes, is a bit objective, more objective than I have heard many who have been opposing the bill from the political front. And I can say to that extent, well, congratulations to him, he's an honest politician. But he mentioned a few things still, even in his submissions now, that I do not agree with. Things also that are not really correctly representative of the reality as concerns the bill in several regards. Firstly, he said that we have had this law referring to the Lands and Deeds Registry Act for 60 years. And there is nothing that we should change now about this law, especially in piecemeal form. But what Honourable Chisanga has not mentioned is that in these 60 years that we have had that law, 60 years of independence, that particular piece of legislation has been changed more than twice. And one of those that are more recent that he will remember, he should remember being a member of Parliament, which are not being talked about, is Act number 40 of 2010. Now, of course, the benefit of the doubt, he was not in government at the time. That was the MND that made that change. But in 2010, there was an enactment of the Lands and Deeds Registry Amendment Act number 40, which was targeting specifically sections 2, 11, and 81. Now, Honourable Chisanga knows that those three sections are connected. In section 2, that act amended the interpretations where it says court. The definition of court there was to include the Lands Tribunal. And there was insertion of the Lands Tribunal in that amendment. Section 11 was put there to introduce also court or Lands Tribunal. Now, the reason it was put there is because it has historically been that under Section 11, the registrar has had the powers always to make rectifications to the Lands Register. And again, I must, not Mr. Banda, I didn't say rectification to the title deed. I have heard this misrepresentation put out there, but the powers that the registrar enjoys under Section 11 is to correct or rectify the Land Register, not the title deed. And Section 81 talks about the appellate procedure from the land, from the decision of the registrar. Of course, Section 11, subsection 1 gives the registrar those powers to do the rectification. Subsection 2 of Section 11 says if anyone is aggrieved by the decision of the registrar, they go to court. Now, in 2010, the government says instead of saying they go to court, the High Court is too burdened by these matters. Let us create a parallel tribunal that will address the matters. Now, why did the government at the time decide to create a parallel tribunal, the Lands Tribunal, instead of just creating a division of the High Court to be handling land matters? The rationale was that this issue should not be an exclusively or strictly litigious matters. The rules of procedure, the rules of evidence in the High Court are very strict. The procedure there is over the head of most of us common citizens. In the Land Tribunal, the rules of procedure and evidence are laxed. Common men can easily access the Land Tribunal. That's why Section 11 was amended to include that the appeal can be either to the court, and the court there being the High Court, or the Land Tribunal, as well as Section 81. But you see, more recently, you have to remember this, Act number 39 of 2021 was amendment of this very Land and Deeds Registry Amendment Act. He was in government at the time. He was part of the ruling party. Anyway, that bill was assented into law on 19th May 2021. It was his government that amended that bill. Now, Mr. Banda, I don't know if you know about that bill or about that act. That is how secretive it was. But they passed it anyhow. They had members. But these are politicians anyway. I'll not be bothered by that. These are politicians. They passed it. No one was consulted. The bill even came. It was not even announced the way this one has been announced. Now, I'm not a politician. Politicians can dicker all they want, all day, every day. We'll still listen to them. But the simple request we make of them is that let them not throw their jabs at each other in our name, in the name of the public, or pretending that they are throwing those jabs in public interest. And let them not be sanctimonious about it. Because if Mr. Chisanga will stand there and say that this is not a listening government, they are not consultative, just 3 years ago, they passed an amendment of the same law themselves. They did not consult anyone. They are lucky that at that time, the public did not lock onto that amendment to create the outcry that has been created now. Maybe it is because access to information during their time in government was more restrictive than it is now. People then could not as freely express themselves as they are able to express themselves now. But let them not use that as a yardstick to say that they were consultative. This government is not consultative because of the public outcry. I challenge Mr. Chisanga to tell us how many people they called as witnesses, common people like myself, they were called, to submit on Amendment Act number 39 of 2021, the one which created, and you know what's very shocking? Some of the opponents of this bill, Mr. Dixon Jerry in particular, when he appeared before TV, he said that currently the government is issuing digital titles which are not backed up by any law. This law, referring to Bill 13, should be dismissed. It shouldn't be heard because there's no agency for it being enacted. Okay, what we should be talking about now is the enactment of a law that allows this government to issue digital titles because there is no law in place. And I sat there as a layman listening to a lawyer telling potentially 20 million Zambians that there is no law that allows the government to issue digital titles when Honourable Chisanga's government passed Act number 39 of 2021, which created the digital registry and created the issuance of digital titles. And Mr. Chisanga has not even addressed that issue. I don't know if he's going to call Mr. Jerry and tell him that you are wrong, you misled the public, there is a law in place, you must apologize to the public for misleading, and probably even to the government for creating the impression that government is acting outside of the law or without the law. But you see, like I said, these are politicians, let them politic all they want, but let them not do it in our name and sometimes at our expense. He's talking, for example, about the Magna Carta and how that it's been an 800 years old piece of legislation.
And please, Mr. Elijah, not to cut you short, but what I would just like to say is that begin to wind up now or begin to conclude your statement.
Okay, fair enough. Let me just go to the point then why I supported the bill before Parliament and I support it even now.
Right.
Consider this scenario, Mr. Banda. Government has offloaded plots to the public. They've created plots, whether by way of new conversions or creation. And they have been offloaded to the public. Both you and I apply for these plots. And our names come out. We are given the invitations to treat. We pay the prescribed fees. And the offer letters come out. Again, we pay the prescribed fees. Then we do the sketch diagramming. We do the survey diagrams, and the properties go for numbering. Now remember, we are given plot. You are given plot A. I'm given plot B. NRC, your invitation to treat, your offer letter, the survey diagram, approved survey diagram, and the numbering on plot A are all yours. The number has been given to you. Mine is on plot B. But at the final stage, I finally put together some money to pay for my title, and I pay the prescribed fee for the issuance of the title, which is the very last stage of this process. I am given a title in my name on plot A. Now, Elijah Simba has been given a plot on title A. A few days later, you find the money also, you pay at the registry, and then you are supposed to be given the title. And then they say, wait a minute, there is an error here, Mr. Banda. We're sorry. Your plot A, was in error given to Mr. Elijah on title. And we're supposed to rectify the record. Yours is plot A. That's where all the other constitutive precedent documents are. Elijah's plot's constitutive precedent documents are plot B. Fair enough, this was our error. Now, the registrar has got two options, yes? To call me and say, Elijah, that property we gave you was given to you in error, it belongs to Mr. Banda. You must surrender that title so that we revoke it, we cancel it, and then issue title, that title number in the name of Mr. Banda, who's the correct owner, and then we issue you title B, where your documents and the details are. But you see, the registrar under the current regime, legislative regime, cannot do that because she has no power to cancel. So the second option is, she'll be forced then to put your name to superimpose your title on top of my title. Because the document so that this is your plot, title A, plot A. It is your land, but it's in my name. So she's forced to issue another title on top of the title which bears my name to issue it now in your name. Now that results into the absurdity of double allocation or double titling, which has bedeviled the Ministry of Lands for years, and these cases are in thousands. However, the solution there then under the current legislative regime is that go to court. Now, who goes to court? Who sues? Okay, you sue. Against whom? Against the government. Okay, you sue the Attorney General you sue the registrar through the Attorney General. Maybe you sue me also. But look, did I steal your property? I didn't. Did the Attorney General steal your land? He didn't. It was an error. It's an error which Section 11 allows the registrar to correct in the land register. But you see, she can't do that correction without cancelling that title which was issued in error. And the challenge now is that what Section 11 gave in 2014, the Supreme Court in deciding that the registrar can only make corrections in the register but cannot cancel title, it essentially took away the powers of the registrar under Section 11. So Section 11 as it is, it's very academic, is of non-effect because there are certain corrections in the register which the registrar cannot make without cancellation. That's the point that these people who are trying to argue against the bill with political lenses are not getting, are not appreciating. But these are the real issues that common people are facing. And now what they're saying there is, well, they just fold their hand and says, Mr. Banda, go to court. But then you're saying, I don't have money to hire a lawyer. So, oh, too bad, go lick your wounds in silence. Otherwise, I can't do anything for you. The impression they have created is that cancelling that title for the registrar is going to be taking away citizens' right to land willy-nilly. In this scenario, Mr. Banda, if the registrar cancels the title which was issued to me in error, she has not taken away my rights. In fact, she has only enhanced and secured your rights. Because if you're a person who is unlearned in the law, you're not familiar with the processes, especially the rigorous, litigious court system that we have currently in Zambia, where some judges, the first thing they ask is, are you of counsel? Meaning, are you a lawyer? And when you say no, they say you have not present before me, I can't hear you. It means just like that, your right of claim to that land is curtailed. You don't have money to hire a lawyer, forget about it. But in asking me to surrender that title so that it is cancelled, the registrar hasn't taken away my rights. My rights are on title B. She will issue me a title on D. This is as simple as that issue was trying to do. But let the politicians do all their fighting all they want, but let them be very objective to some extent. The amendments to that law, Honourable Chisanga should not convince the 20 plus million Zambians who might be listening to him that it has remained changeless to the same since 1960. It is not a perfect law. There is no perfect law on the face of the earth. The very Magna Carta he is referring to has undergone several transformations. In any case, Henry VI at some point, 200 years after the setting up enactment of the Magna Carta, had completely rejected it or returned to feudalism. So, law is supposed to comport with the changing values of society that mark the progress of a maturing community. Law is supposed to answer to the challenges of the people. You can't stick to an archaic law simply because you are opposed to the government in power at the moment. You don't cut off your nose to spite your face.
I think
I should make a point that there is a lot of politicization around this bill, and the politicians who have taken this as a worthy instrument to get into the ring and hit each other in all sorts of ways, well, they have a right to do that, and politicians always do that. But let at least there be application of some objectivity. And when they are fighting each other, let them not do it in our name, and sometimes let them not do it at our expense as ordinary citizens.
Mr. Elijah Simbai, I thank you very much for coming, and deliberately we had to call you because obviously the fact that you made submissions as well and you're a witness to the committee, we really are thankful for your contribution this morning.
I'm grateful for having me on, sir. Thank you so much. Well, I only wish that there could be a platform created where both sides of this divide can be present, where they can face off and present submissions with equal opportunity so the citizens can judge objectively.
Indeed. We take that into consideration. Thank you very much, Mr. Simbai.
Thank you very much.
There you have it, Honourable Chisanga.
Yes.
That is one of the stakeholders who, just like yourself, was witness to the before the committee and made submissions in favor. But a quick reaction to what he says from you before I take phone calls from the general public.
It's quite loaded. I don't know whether I'm going to do justice to all of it. And I'm glad that he acknowledged that I'm trying to be as objective as I can be.
Right.
In my approach to leadership, everywhere where I've been, not only in the political space, I try as much as possible to be objective.
Right.
And in going before this committee, I even told them I'm not appearing as a politician. I was appearing there as a lawyer who has been practicing his law in the area of conveyancing.
That's right.
And I thought I was going to help the committee in that area. But I just want to say, to raise my appreciation to Mr. Simbai for the way he acknowledges, how I approach my issues to leadership. It's very comforting to hear that, especially, when people don't like politicians. Every time I come here, I always tell you that I don't like calling myself politician, because when you say I'm a politician, people begin to think everything negative about you.
Absolutely.
I'm glad that I begin to portray a politician, I think, who is quite objective in dealing with these issues. Coming to the matters that Mr. Simbai has raised, the first thing he's raised is that I may have misrepresented the facts by saying that the Lands and Deeds Registry Act has not been amended. I wasn't actually saying that. I was saying that the provision in the Lands and Deeds Registry Act relating to title holding has not been amended for 60 years because there's no problem with it. Other areas of the Lands and Deeds Registry have been amended. I'm aware of this. Yeah. So either because I've been with the PF government, but also because I've been practicing law for a long time. Every time there's an amendment, we are made aware. For instance, I can tell you that the issue of digital certificates of title was brought to the attention of the Law Association of Zambia, and I saw a draft before it was amended, and people went before the committee. In that time, I wasn't in Parliament. This is about in May 2021. I went into Parliament in September 2020, rather. I went into Parliament in September 2020. But even if I was in Parliament, I can remember that there was always an attempt to consult before the law came.
Only an attempt.
It's always an attempt. Even what UPND is trying to do now is an attempt to consult. But the question, the issue I've raised here, which I will repeat all the time, is with politicians, we should always demonstrate wide stakeholder consultation before we effect amendments to the law, especially amendments that are very, very important and that implicate the law. Digitalization of certificates of title was part of implementing international conventions, because everybody was going digital, and that need was felt. And Mr. Simbaya may not have established whether there was consultation or not, but I can tell you for a fact there was consultation among stakeholders, because Smart Zambia is running with that agenda. The time we brought in this consultant from Israel, the one who set up the land tenants, I think Zimis or something, which is now the platform that they use to issue certificates of title. There was wide stakeholder consultation before that happened, including getting the Minister of Finance, Mr. Chikwanda, to set up teams that went around to explain these things to the people. So consultation actually was there. Mr. Simbaya has raised a very interesting issue. He's raised only one aspect of why he was supporting this bill. He may have supported it from other respects. But if I'm going to take the issue that he raised, one of where the registrar makes a mistake at the time of issuing certificates of title, issue certificate of title A to you and B to me, when I'm supposed to be on land A, I'm supposed to be on land B. These mistakes are common in the Ministry of Lands, I can tell you that. But here's what I said when I appeared before the committee. I was saying, if the registrar is competent, if the people that are working in the registry are competent, this is not a problem I expect to occur in the Ministry of Lands. I shouldn't. The reason is because I think over the years, and this is not only unique to the UPND government, over the years, we have allowed people that are not competent to get into these offices, either as from clerical staff to directorial staff to even registrars themselves, who may not honestly be very competent. When I was practicing law as a young lawyer, sometime in 1993, 1994, there used to be a gentleman called Mr. Khan, who was a registrar of lands and deeds. We used to find that man very hostile. We used to think there was something wrong with this man. But you see, he'd come through a system where he had learned how important land titling is. He wanted to make sure that the proportion of error is reduced. And he used to demand, competence and, capacity when you're going to deal with that, with lands. The area of law that is very difficult to practice in is conveyancing, because you deal with land titling and the kind of documents you have to file before the Ministry of Lands just to transfer a title from myself to you, Mr. Zach, is very, very complex. And that area, very few lawyers, even in the practice, actually understand it. So the quest is to make sure that you get people that are competent, firstly, to practice as lawyers, and also you get people that are very competent to manage or to assist the senior registrars to manage the affairs of the Lands and Deeds Registry. At the time I was a young lawyer, there was only a registrar. Now we even have a senior registrar who's assisted by various registrars. Why? We responded to the fact that so many people have started acquiring titles to land, and we need to increase capacity in the office of a registrar. And the issue that Mr. Simbaya has raised, if it does occur, there is within the area of conveyancing practice where you can rectify those entries in the registrar. In the registrar, without necessarily going to court, because you can do deeds that show that you are switching titles because there were issues and either issued a mistake. What I was saying is there is a procedure that you have to comply with, but I must insist that the power to cancel certificates of title is an aspect of what is called equitable jurisdiction of the High Court. Because, when you have got to determine whether you should, cancel certificate of title or not, the other secondary question you have to ask is, what are you going to do with that accord and exhausted improvement on the piece of land? Because, you see, land is just not on a certificate of title. Land is being defined as land and the fixtures that are on the piece of land. In certain cases that went to court, fixtures were considered even, like a power, like an equipment fixed to a piece of land, not necessarily a building. It was considered to be a fixture, because for you to decide whether this is land, you just don't take the land that is on the ground, but you also take into account whatever has been erected there. So if you cancel a certificate of title, you need to then determine how we're going to compensate the person if he's entitled to compensation, how we're going to deal with that matter. And only a High Court is able to do that. The reason why I cite the Magna Carta is not to say that we have stayed with the same law, for 800 years. Even when I was speaking before the committee, I said, this is a law that has been developed, it has been improved upon. But in a quest to improve upon it, we haven't moved away from the original concept of why it was necessary that the registrar, who is the one who issues certificates of title, must not be allowed to be the one to cancel certificate of title. You actually open up an industry of corruption if you do that. This is a person who, if they conduct themselves with due diligence, if they conduct themselves, apply themselves correctly, firstly, they are educated, secondly, they are competent, thirdly, they are experienced, we begin to reduce the error of the areas of error in issuing certificates of title. But if peradventure, a certificate of title has been issued in error, then there must be an independent process through which we are going to take that corrective measure. The initiative that you brought in of the bringing in the Lands Tribunal was a response to the people, who were decrying the fact that cases are taking too long in the High Court. And they said there are certain disputes that don't have to do with certificate of title, certain disputes that have to do with other areas of land management that can be dealt with by Lands Tribunal. In fact, the Lands Tribunal is an evolving institution, because elsewhere within the Commonwealth, this is an initiative that has been embedded into the legal system, but never to do with cancellation of certificate of title. Although we are now gravitating towards the area where we want to have a land division in the High Court itself, where we have judges dedicated only to dealing with land disputes. Like we have judges only dedicated to do with family issues and judges that are dedicated to dealing with commercial matters. So we need to be able to say, how do we respond to the issues that Mr. Simbaya, for instance, was raising here? You need to build capacity within the High Court structure itself, because you can't move away from a constitutional dictate that says only a High Court judge must cancel a certificate of title and then pass it to because if you have to do that, if this initiative, for instance, has to go, assuming Zambians are agreeable that the registrar, must be allowed to cancel certificate of title, you must then amend the Constitution, because the High Court has been jealously granted constitutional mandate to deal with land matters, including cancelling certificate of title. But you can't just go and change the subsidiary legislation and leave it hanging in the Constitution that the High Court is the one that is created with this power.
Absolutely. Let me. I know that we did start our program very late, and I know that we've even gotten some extension by our executive producer. But quickly, I will take a limited number of phone calls. I will probably just take 5 that you have to respond to, and then we begin to close. Good morning.
Yes, good morning.
Morning to you. Thank you very much for calling. You have a minute. Please utilize it. Your name and where are you calling us from?
We're talking to Vashimagi within Lusaka.
Yes, please go ahead.
Yeah, this bill, it's talking about there's no compensation, or if you buy illegal plot, illegal farm, then you need to be compensated. So the fact is that you have buy something where you should not build, and you build a mansion, definitely you lose that property, and that property will be demolished. We have seen illegal plots, illegal farms in this country, where designated area, it's not designated area, people are buying anyhow. Where in Kaunda, if we are talking about Kaunda, in Kaunda, there was a residential area and farming area. Today you are finding that along the railway line, along the road, they are just building. And when you are building and you build a mansion, make sure that when you buy a plot, buy to the right people, instead of cadres or any people who does not have a right to sell you. Thank you so much.
Thank you. We appreciate for keeping time.
Thank you, Mr. Rashmag.
I'll take another one on 0955 221515. Good morning. Good morning.
Francis Mumbe, if one of movies are calling you from the Lusaka town.
Francis Mumbe, you have a minute, please. Make sure you stick to that. Please go ahead.
Yes, please. Yes. Honourable Chisanga, you're speaking very well. I'm very impressed with the way you've done things. You're a true patriot. You know what you're doing, you know what you're talking about. Keep on sensitizing the people. I've learned a few things from you that I may not have known, but I think you've done justice to everything. And what you've said. Everything is clearly pointed out. At the end of the day, what you are saying with this law, I think I've heard you saying that certain procedures need to be followed when you want to change a certain bill 13, whatever. It's not just waking up today in a small corner, you sit down, and then you decide tomorrow we're going to enforce this. No, it's not allowed. That. So people like you who are there even in Parliament safeguard what belongs to the people of this country. Processes should be followed the way they should be. And then also, as I conclude, if we give the registrar all the powers, Commission of Lands in Wachani, High Court in Chisanga, Land Tribunal, and even the Court of Arbitration, whatever. Why would they be there for? Because registrar now has excess power and to be susceptible to corruption. Corruption will be even at its worst. That's what I can say. Otherwise, I think within 1 minute. Thank you very much, and we thank the radio station for the good work that you're doing by bringing high-profile people and being fair and firm. We love you so much.
Thank you. Thank you very much for your contribution, Francis. Let me take another one on 0955-221515. Good morning. Oswald. But Oswald, kuliko chongo kwa nini mulili so timvera distorted information. Please. Okay, fine. We just had someone in the background who was shouting and we couldn't hear you. Please go ahead.
Okay. So
Right.
Thank you, Oswald. Let me see if I can get the last two. I have one or two comments on Facebook as well. Good morning. Just reduce the volume on your radio set, please.
Yes.
Good morning.
Good morning, Zach.
How are you today?
I'm okay.
Your name, sir, and where are you calling us from?
I'm Sakavantu.
Mr. Sakala. Musakavantu. My apologies for getting that wrong. Musakavantu. Please go ahead. You got a minute.
Thank you so much. In the legal fraternity, the late President Manawasa says you can train a lawyer for 99 years. That's a long time. And he says life is illegal. Then there's this issue of state lodge where people have gotten titles. Is it right to make the wrong thing to be right? How do you defend people who have encroached on state lodge? Well, that's a presidential lodge. And people have built there and they have titles. Who gave them the titles? And then you defend such people who have gotten titles in such a manner. Thank you so much, Zach.
Thank you very much, Mr. Musakavantu. And of course, let me see if I can take the last one on 0955-221515. Good morning. Tauka mauka bwanje.
Mwibwanji bosi.
Bandani zina? Sepiso. Yes, Sepiso, you have a minute, please. Make it quick.
As long as peace, it's so easy. Every time we consider things, criminal kuvutika fuatani mindset ya tunapasa wote ni wazungu. As long as wakati kama bill sagati kushinga ni wazungu. Hizi wanoziva. As long as mindset tinangale bonke bopuma ngamba macho kufoka sikutuka na ukapaka kutukamba kuipa singa zikapeza kamba kuipa kupani. Na mechengera kuti bantu vanenda vani ku school ndio tizikati. Bandi vati bayimo vintu bazozero kumakama kama lawyers. Bazo kuti ivintu komisienda sivaza ngoro vanti kuisa bazungu. Nifa kuboteka peka but as long as it's accelerate bazungu tembera kusogoro. Niso chedza mukari singorira. Kuba vintu beva mafika ntanga tenda ukubazisa pasi vama but muzungu muno ndio number 1 tunza kapasa muzungu karibe aina land karibe title because but mbao ndako ine ni betai. But tina makuna matina manama but kuriba tuwasatu kutuwa tatu kutuwa ndara. So mindset ya ima black team so bazamu kala that's what people what mindset mamire mali does ngomekame ngomenda ndemuleka vote what corruption there is as long as ukupata tembera muzungu vote visible ndezo as long as mindset ya singa kishika very should be traore ni so jambo tingo vuta anachepa bani fuata ni bazungu zote watu bali free as long as mindset ya bin traore kishika mso tabi kama ndivyo ngambi mindset change.
Zikomo let me give you quickly what I have on Facebook. This one is from Gradel Mundea, who says, I think the Honourable is offside when he said that the minister should not actually consult the chiefs for them rather to be involved. Chiefs are Zambians who are supposed to be engaged. Just individuals like lawyers such as Dixon Jere also submitted. Okay, so I think it's on the issue of what the minister said. Yeah. Then we have Henry Mavimba who says, good morning. The current law on land is okay. If there are any deficiencies that have been identified, the best that should be done is to find a way of correcting the deficiency. To remove the arbitration aspect from the court to the registrar pertaining title deeds is ethically incorrect. It's tantamount to self-review. You can't actually have an institution that issues the deeds to again over their wrongs in issuing title deeds. Honourable MP, how can you ensure such bad bills don't come back to the floor of the House? All right. So quickly, maybe I will allow you to respond as we conclude. Honourable.
Right.
Yeah.
You have loaded me.
I know.
I think Bashimagi gave very good advice, and I can only sum up in one sentence.
Right.
Please, when you're buying plots, buy from the right people. Because if you buy from the wrong people, you are going to have problems. Okay, Wambi, I think he was just
appreciating what he's learned of you.
Yes.
Yeah.
Oswald was asking about Bill 7 and Bill 13. Oswald, the voting pattern in Parliament is different depending on which bill is being voted on. Bill 7 is a constitutional bill. It requires 2/3 majority. Right now, the UPN does not have 2/3 majority, but that doesn't mean that they can't pass Bill 10. Bill 7, sorry. If there are MPs on the other side, the opposing side, or even the independent who think that Bill 7 must be passed, or who may have been persuaded that they should pass Bill 7 and they get 2/3 majority, it will pass. Bill 13, it's a simple majority that is required. Currently, the UPND does have numbers. But the issue to address, Oswald, is whether these bills are progressive or they are not. And the point I've been making on the radio is that these bills are not progressive. We have actually made an appeal even to our colleagues in the UPND to consider the contents of Bill 7, and look at where the electorate send them to Parliament. The independents we've also canvassed by amongst ourselves as PF. We agreed that Bill 7 is a law that is a constitutional amendment that should not be passed. We hold the same views on Bill 13, like I've tried to demonstrate here, that this is not a good piece of legislation. It should not be passed. Mr. Msakabantu, I think, has raised a very important issue. The issue is whether people that have encroached on state land or people that have acquired titles in places where they should not acquire titles should actually be allowed to go it. Mr. Msakabantu, and I'm grateful you consider Mr. Mwanawasa as one of the heroes from what you said. Mr. Mwanawasa, for me, was one of the greatest lawyers this country has ever produced. I learned so much, practicing law again alongside him. But the position is that if anybody has a grievance on people that have acquired titles, at State Lodge, when they should not have acquired titles at State Lodge, the same provision I've been trying to talk about, which gives the High Court power to determine whether these were legal titles or they were not legal titles, can be recourse. Mr. Msakabantu may need to be reminded that there's a case in this country where the High Court and the Supreme Court both allowed somebody who was merely a caretaker on a plot where they didn't even have a certificate of title, but which plot was wrongly allocated to a church, and the church actually constructed, its building on that piece of land when the matter was in court. The High Court made a finding that the person who had been left in charge of that land by a departing, a white family that was living on that land had what the Supreme Court called an incoherent interest in that land. In other words, the Supreme Court said the registrar, before issuing a certificate of title to that church, should have gone to the ground, carried out inspections, established whether the people that were on that land had any interest. This gentleman who died, and the daughter is the one who took the matter up to the end in court, was a worker of this white family. They had given him a piece of paper where they told him he had been given that piece of land. That the court found was sufficient to create what is called an incoherent interest. And the court made a finding that the certificate of title that had been issued to the church should be cancelled because it was illegally issued. The same, principle can be applied if you took this case to court. And anybody who has illegally acquired land in State Lodge, we don't have to change the law, to give the registrar powers to go and cancel those certificate of title. When an existing law, where there's even a precedent, where the court has made findings that somebody who's been given a certificate of title wrongly must be made to vacate. So, Mr. Kabantu, I agree with you. People should not be allowed to build on places where they have illegally obtained certificates of title, but we have a process that deals with this matter. Sepiso, I think, was just decrying role that we leaders are playing in the country, and with some justification, sometimes, although it doesn't relate only to the issue that we're discussing here, but quite frankly, we as leaders have got a duty to remember that we are trustees for people who have the constitutional right to live in this country. The Constitution is very clear on what a leadership role is, be it a member of parliament, a judge, or the High Court. We are trustees for and on behalf of the people. So I agree with the people that sometimes we have got an overreach as leaders when we hear, investors bring in all these niceties that give us maybe personal benefits, and we think that because of that we should be able to sell our birthright to those people. I think it's an appeal that Sepiso is making to the leaders, and Sepiso, you are right. You are not doing anything wrong by reminding us leaders, kutikumbukisa if leadership as your leaders, we are doing it for and on behalf of you people, and not on behalf of people that come from elsewhere. I think Mr. Mavimba has clearly stated that there's nothing wrong with this law.
But he said, how can you make sure that such don't come back?
Well, I think for me, you have heard what the government has said. They want to come and consult. Make yourself available, Mr. Mavimba, to be consulted. State your position to the government. I'm very sure if this government is as listening as it is said it is, when people like Mr. Mavimba tell you that Bill 13 is a bad law, just don't bring it back to Parliament, because you're doing it if you're doing it on behalf of the people, and the people tell you we don't want it, don't bring it to Parliament. For me, I've just demonstrated in answering to one of the questions, to Oswald, that currently the way Parliament is tilted, the UPN has got a simple majority, and passing any law of this nature is a simple majority. If they bring it back to Parliament, even if we argue against it, they're going to pass it. So for me, it is now to capture the opportunity when they've said they're coming to consult, be available, talk to them and tell them why you think this can't actually be done. I think somebody was saying I was offside when I talked about the minister consulting chiefs. I didn't straight jacket that position, but I said we need to be alive to the fact that traditional authorities are responsible for managing traditional lands. Yes, you can consult them, but what are they going to say relating to the issue, which is titled land? We've got no jurisdiction. So for me, I am trying to target the minister to possibly find, people that can assist the country to come up with a law that is progressive. And that's why I pinned out the Legal Development Commission. Yeah. I pinned out, scholars in the schools of law and legal practitioners who are practicing in the area of conveyancing. Go and speak to these people and make comparative analysis with other countries. Establish what is happening within the jurisdiction of the Commonwealth. And you will establish, the way to the law must be progressive. And the final point I make, Zach, is that Zambia has been in need of the policy on land reform and the policy on law reform relating to land for a long time. We need to take a holistic approach to try and see how we can deal with this matter. I'm sure if you speak to some of the lecturers who are teaching land law in these good universities in this country, some of them I think are already sitting with manuscripts on their tables on what they've identified are problems with land legislation in this country and land administration. Those are people that you can then engage and say, help us, we need to do this. In 1994, we amended the Companies Act after a very long time. I had just come myself from my master's program, and I was a lecturer at the University of Zambia. Ministry of Commerce at that time asked the University of Zambia to volunteer some lecturers to come and sit. I was volunteered as one of the people that researched and established the Amendment Act of 1994, the Companies Act of 1994. At about the same time, we also amended we introduced the Securities Act, which set up the Lusaka Stock Exchange. There were such wide consultation that when that law came into effect, it was received very, very properly by the Zambian people. I'm actually thinking that if the UPND wanted to demonstrate that they want to improve land management in this country, they should approach it in the same way the MMD approached it in 1993, 1994, and bring about an approach to holistically look at these laws that apply to land and amend them at the same time, including this very clause that they're talking about. In the event that Zambians will agree that the registrar must be given powers, subject to adjusting the actual positions in the law, they can actually achieve what they want to achieve. But what I condemn, and I condemn it, I think, with justification, is this idea of just thinking that because there are problems in state lodge or elsewhere in the country where people are acquiring land without following due process, then you should give the registrar powers to start cancelling titles. You are creating another problem that will be very difficult for somebody to manage in the future. So we should be able to be careful of that, but also we should pay attention to the fact that you can't just amend one piece of legislation when you're supposed to be doing a holistic approach to amending the laws.
Your concluding remarks.
My concluding remarks are that quite frankly, Bill 13 is controversial, and it does not, respond to the aspiration of the Zambian people. It is retrogressive. It cannot be progressive in its current form. If peradventure some consultations are going to take place, I would just encourage Zambians. This is about your right to own land. This is about your future and the future of your children. You know, land is the only tangible property that can be handed from one generation to the other. We must be interested in knowing what government is trying to do with land titling in the country, and we must rise up to the occasion and explain to the government what we would like to do. If it was done in 1215 by the subjects of the king in England, you know, and they ended up with Magna Carta, which Mr. Simbaya was trying to condemn, why shouldn't it happen now in 2025, 810 years after that? Why can't we prepare for the future of our children and our grandchildren by speaking to this government and telling it you can't change the land titling system from what we have right now, because there's quite frankly no problem with it. They should only change laws if there are problems with the laws. One single problem should not result in law reform. That is not how we are going to amend laws progressively. Thank you very much.
Honourable George Chisanga, I thank you very much for coming. And of course, we appreciate that you came and shared all that has been burning lately with the general citizenry. Well, listeners, that was our guest today, Honourable George Chisanga, PF Legal Committee Chairperson and Lukashya Member of Parliament. And let me say at this point, thank you to our partner radio stations, Katete FM in Eastern Province, of course, Spice FM in Kabwe, and ZFM in Kapiri, Muchinga Radio in Chinsali, Tuta FM in Mansa, and iWave FM in Chingola, including Platinum Radio in Ndola. From all of us here is take care of yourselves and more so of each other. Bye-bye.
Thank you.
The edition of The Burning Issue, and thank you for your participation. Democracy and freedom of expression is about tolerating the views that you don't